Hey all, Professor Tracy back with another video from Law Simply Explained. This one, we're still looking at consideration. We're going to look at past consideration and moral obligation. We'll start with past consideration. So when we're talking about past consideration, it is kind of what it sounds like. It's the question of whether something that has occurred in the past can be considered bargained for. So if the promisor is making a promise in recognition of something that has occurred in the past, can that be consideration? Can that be the detriment that was induced by the promise when we're talking about a bargain for exchange? And you'll see there the general rule, which is no, that's going to be unenforceable. It will not make the promise enforceable. It will not satisfy the element of consideration. So let's look at an example. Bob says, "Barb, thank you for washing my car yesterday. That was such a nice surprise. I will pay you $20 for your work." So we have a promise, right? We know we have a promise from Bob to pay Barb $20. And Barb has done something in the past, right? She has washed Bob's car and she says, "Oh, you're welcome." And the question is her washing of the car in the past and Bob's recognition of that, is that consideration for his promise to pay her $20? And the answer is no, right? That's a straightforward application of our rule, because when we look at the rule for consideration, which says there needs to be a bargain for exchange, and the first part of that says that the promisor's promise must induce a detriment from the promisee, so Bob's promise to pay $20 must have induced a detriment from Barb, then that is not true here, right? Because she had already washed the car. His promise to pay $20 is not what induced her to wash his car. That had already occurred. It's in the past. So right out of the gate, the bargain for exchange fails because Bob's promise did not induce a detriment from Barb. And that's true with past consideration generally. So we can say, no, it doesn't work. The first part of a bargain for exchange is not satisfied, and therefore there is not consideration. So what about moral obligation? So generally, again, moral obligation will not serve as consideration for the enforcement of a promise. Now we'll see with both these rules, past consideration and moral obligation, there are some exceptions. And right, we're in law school, so we know there are exceptions for everything. And so let's look at an example. Barb says, "Bob, you're a great friend. I've grown quite fond of you. I want to make you some chocolate chip cookies to show you how much I care for you. Would that be okay?" So she's promising Bob to make chocolate chip cookies. Okay, so she's committed to doing that. And Bob says, Of course, Barb. Thank you. I'm quite fond of you as well." So the question is his friendship, their fondness for one another, their ongoing friendship and love for one another, is that consideration for her promise to make him chocolate chip cookies? And the answer is no, it's not considered a detriment, right? We are not at all sentimental in contract law. You know, we could say we are cold-hearted. And so here, while there is a promise from Barb in recognition of their friendship and their fondness for one another, that is not consideration. So her promise hasn't induced any detriment. You could also say that she's recognizing something that occurred in the past. Not only is it moral obligation, it's also something that occurred in the past. Maybe he turns out to be not such a great friend moving forward. But either way, her promise would not be inducing a detriment. So moral obligation doesn't work. Now, that's not always what people think of with moral obligation. So let's look at a more typical case, although the standards here, or the stakes here, are not as they are in some cases we'll look at later when we go through these lessons. But this is maybe a more typical example where we think of moral obligation. Bob says, Barb, thank you. I heard you were the one who found Buzzy. Sure. Truthfully, it was a little intimidating. Buzzy is quite large for a bee, but you're welcome. Well, I want to do something for you for placing yourself in danger like that. Buzzy means a lot to me. I will pay you $100. So Bob has promised to pay Barb $100 in recognition of what Barb did to rescue Buzzy for him, right? Placing herself at risk in order to save his pet bee. That is what he's wanting to recognize. And so our question is, well, is that, right, her doing that for Bob, is that consideration? And there's really two problems with that, right? One is it's in the past. So just like with the car washing in example 1, that's not going to serve as consideration because his promise did not induce the car washing, just like it didn't induce Barb to locate and risk herself to bring Buzzy back to Bob. That doesn't work because it's past consideration, but also any sense of moral obligation that might be felt here, right? That if there's this moral sense of, well, she did risk herself in order to provide a benefit to Bob. And so it's tempting to say, well, that should be enough to supply consideration to make Bob's promise legally enforceable, so that if he were to change his mind, that Barb could run into court and try to enforce it. But the law is generally cold-hearted. And again, we would say no, that his promise is not supported by consideration, right? That there is no detriment that was induced by it. Because one, it's in the past, and two, any sense of moral obligation that may have kicked in because of Barb's actions in risking herself to bestow a benefit on Bob is not sufficient to satisfy consideration. And the stakes could even be much higher, and we'll see that later when we're looking at promissory restitution, how that comes up under sort of general contract law, that even if the stakes are quite high, where someone is risking their life in order to prevent someone from being seriously injured or saving their life, that moral obligation is not sufficient to supply consideration. So here, again, there is no bargain for exchange, and therefore the element of consideration is not satisfied. Of course, because it's contracts and it's law school and we're learning the law, there've got to be exceptions. And so there are 4 exceptions. We'll talk in detail about 3 of them, and then we'll put a pin in promissory restitution because we're going to look at that in detail in a later lesson. But the first 3 are very similar. There's kind of variations on a theme. When we say these are exceptions, what we mean is that these are situations where the rule on past consideration or moral obligation does not apply. That it is enough in these cases, that we say that there is consideration that in these situations such that the promise is enforceable. There is consideration for it. So that's what we mean by an exception here. So the first is a promise to pay a debt that's barred by the statute of limitations. So what we have in view here is that the debtor owes the creditor some sort of debt. The statute of limitations has run such that the creditor cannot legally collect it anymore. The debtor is not legally required to pay it anymore, but the debtor feels morally obligated to promise to pay it. So they come to the creditor and they say, you know what? I want to pay that debt even though I know the statute of limitations has run, it's not legally collectible, but nonetheless, I promise you that I will pay it. And often that's because they feel like, well, I've come into some money, I feel like that's the right thing to do. And ordinarily, we just said that doesn't work. But in this case, it does because it's an exception. And keep in mind, there's nothing new coming to the debtor when they promise to do this. They're at best recognizing some benefit that was bestowed on them in the past, right? Some money that was loaned to them in the past or credit extended to them, but nothing new. So this is, not only is it that it's past consideration and or moral obligation, but that would normally mean there is no consideration. But here it's an exception, and there is. Very similar, we would treat it the same way if it were bankruptcy rather than the statute of limitations. Same exact pattern, that the debt's discharged in bankruptcy, the debtor comes forward and says, nonetheless, I've come into some money, I feel like it's the right thing to do, I promise to pay it. That promise ordinarily would not be enforceable because the consideration coming back is past consideration and or moral obligation. It would not work, but this is an exception, so it does. Then this one is, we'll give a basic explanation of it because we'll look at it more in the context of defenses, but ordinarily minority is a defense to the enforceability of a contract. So ordinarily a minor can disaffirm any obligation that they incurred as a minor. But one thing that can occur is after somebody reaches the age of majority, often 18 in most jurisdictions at this point, that the minor can now say, they've reached the age of majority, they can say, I want you to know I'm going to make good on that obligation that I incurred as a minor. Even though I know I could void it, I could disaffirm it, but I'm going to affirm it because it's the right thing to do. Similar to the first two exceptions, there's nothing new coming to this person who's just reached the age of majority. So at best, there was something given to them in the past, or there's this sense of moral obligation. Ordinarily, those would not be sufficient to make this promise enforceable, but in this case, it's an exception, so it would be enforceable. And then the final one is one I mentioned, which is an exception for a doctrine called promissory restitution. We will talk about that in more detail later, so just put a pin in that one. This is an exception, but it's also an equitable remedy here, that it's different than the first three, where there are exceptions to the consideration rule. The fourth one is saying, even in the absence of consideration, here's another possible avenue for making that promise enforceable, despite the fact that any consideration coming back to the promisor is past consideration or moral obligation. And we'll look at that, how that works, because there's some other equitable doctrines around it. But put a pin in that one, we'll come back to it. So I hope that's helpful. That's all for now. As always, if you enjoyed the video and hopefully it shed some light on contract law for you, like and subscribe, and I will be back with more videos shortly. Thanks a lot. See you soon.